So hi guys, this video will be discussing on a recent case, Canon India Private Limited versus the Commissioner of Customs. It's a Supreme Court case. The ruling came on 9th March 2021. So we'll be discussing the facts of the case and then the analysis and then the conclusion of the ruling. So this case is mainly on the power or the jurisdiction of DRI to issue SCN under the Customs Act, right? So let's look into the facts of this case. So this case was initiated by DRI, that is the Directorate of Revenue Intelligence, against Nikon India Private Limited, Canon India Private Limited, Sony India Private Limited, and Samsung India Electronics Private Limited. So here, digital still image video camera, that is DSIC, was cleared under the exemption notification 20/2005 as amended by 15/2012. So these goods were cleared under this exemption notification, whereas the DRI in the show cause notice issued under 28 section 4 wanted to deny this exemption benefit, and they sought to charge or demand the tax, interest and penalty under section 28 subsection 4, which can be invoked in a case where there is willful misstatement or suppression of facts. The case went to SESTAT, and the SESTAT also agreed with the DRI, and the benefit of the exemption was denied, and the appellants were asked to pay the tax along with interest and penalty. However, the main issue before the Supreme Court was not on the eligibility of exemption, rather it was mainly on the premise whether the DRI is the authority or DRI is the proper officer who can issue show cause notice under section 28 subsection 4. So if this kind of a show cause notice which has issued by the DRI, is it valid in law, right? So this is the issue which was taken before the Supreme Court. Now let's look at the timelines of what happened in the case. On 15th March 2012, bill of entry was submitted to the customs authorities, and 5 days later, on 20th March 2012, a covering letter and the literature containing the specifications of the cameras were submitted to the customs authorities. And on 21 March 12, the next day, the bill of entry were verified by the inspector and superintendent, and the importer had also requested the deputy commissioner for first check on the goods. Later, on 24th March 2012, the customs authorities permitted clearance after the first check, allowing the benefit of notification of the exemption under notification 15/2012. So this clearance was given by the Deputy Commissioner Appraisal Group, Delhi Air Cargo. So on 19th August 2014, SCN was issued by DRI mentioning that the customs officers, that is the uh, appraisal group customs officer, were induced to clear the goods under the exemption notification, since the goods were capable of recording more than a single video sequence of less than 20 minutes, 30 minutes. So here the DRI was more sticking on to the eligibility of the exemption. So but the question on the Supreme Court, as we discussed, on the power or the eligibility of DRI to issue a show notice. So what is the analysis or what is the discussions, technical discussions that has happened? So first we need to see, since the show cause notice issued under section 28 subsection 4, who can issue the notice under 28 subsection 4? So 28.4 provides that in case of non-payment of duty on account of fraud, etc., the proper officer shall, within 5 years from the relevant date, serve show cause notice. So here, in the case of Consolidated Coffee Limited versus Coffee Board Bangalore, Supreme Court has held that, in quotes, secondly and more importantly, the user of the definite article, the, before the word agreement, is in our view very significant. Parliament has not said an agreement or any agreement for or in relation to such export, and in this context, the expression the agreement would refer to that agreement which is implicit in the sale occasioning the export. So when the word the is used, it means that it should be that agreement which is implicit for the purpose of export and not any agreement. Similarly, in Sri Ishar Alloy Steels Limited, it was held that The is the word used before nouns with a specifying or particularizing effect, as opposed to the indefinite or generalizing force of a or an. It determines what particular thing is meant, that is, what particular thing we are to assume to be meant. This is always, the is always mentioned to denote a particular thing or a person. So it has a specifying or particularizing effect, is what has been held in the case of Shri Ishar Alloy Steels Limited. Therefore, a or an is an indefinitive article, whereas the is a definitive article, right? And if the parliament uh, intended that if the parliament intended that any PO could have exercised the power under 28(4), it would have used the word any and not the. So the usage of this word the has a specifying or a particularized power to recover duty is broadly a power to review the early decision of assessment, and such power is not inherent in any authority. Indeed, it has been conferred by Section 28 and other related provisions. The power has been so conferred specifically on the proper officer, which must necessarily mean the proper officer who in the first instance assessed and cleared the goods, that is, the Deputy Commissioner Appraisal Group, Delhi Air Cargo. Indeed, this must be so because no physical statute has been shown to us where the power to reopen the assessment or recover duties which have escaped assessment has been conferred on an officer other than the officer of the rank of the officer who initially took the decision to assess the goods. Where the statute confers the same power to perform an act on different officers, as in this case, the two officers, especially when they belong to different departments, cannot exercise their powers in the same case. Where one officer has exercised his power of assessment, the power to order reassessment must also be exercised by the same officer or his successor, and not by another officer of another department, though he is designated to be an officer of the same rank. In our view, this would result into an anarchical and unruly operation of a statute which is not contemplated by any canon of construction of statute. The section must therefore be construed as conferring the power of such review on the same officer or his successor or any other officer who has been assigned the function of assessment. In other words, an officer who did the assessment could only undertake the reassessment. Therefore, DRI is not the proper officer to exercise powers under section 28 subsection 4, and hence the recovery proceedings which were initiated are without jurisdictions and are liable to be set aside. Now, the Supreme Court also discussed whether DRI could even be a proper officer. For this purpose, Section 2 subsection 34 defines proper officer as, in relation to any function to be performed under this Act, means the officer of customs who is assigned those functions by the board or the commissioner or the principal commissioner of customs. It is to be noted that there are various rulings which have provided that while all proper officers must be officer of customs, all officer of customs are not proper officers. DRI is constituted under Notification 17/2002 Customs, where the central government appointed the Additional Director General of Revenue Intelligence (ADGRI) to be the Commissioner of Customs, and their jurisdiction extends to whole of India. Similarly, subordinate to them, Additional or Deputy Director General of Intelligence and Assistant or Joint Director Revenue Intelligence were appointed as Additional or Joint Commissioner of Customs and Assistant or Joint Commissioner of Customs respectively. So the department relied on this notification and also on notification 40/2012 dated 2nd May 2012, which was purported to be issued under section 2 subsection 34 of the Act, wherein functions were assigned to each designation of officers. So the department contended that since ADGRI was a commissioner of customs, they can exercise powers of section 28, which was assigned to assistant or joint commissioners of customs. However, it was observed that the notification was issued under the powers of Section 2, subsection 34, which is only a definition provision and does not confer any power on any authority to entrust any function to the officers. Further, Section 6 is the only provision which provides for entrustment of function of customs officers to any officer of the central government or state government or local authority. Therefore, the notification was issued under non-existent powers and was held to be ill-founded. So, the conclusion in the ruling is only the officer who did the assessment must only undertake the reassessment under section 28, since the word the, a definitive article, precedes the word proper officer in section 28 subsection 4. Therefore, the proceedings initiated by DRI under the said section were without jurisdiction and is liable to be set aside. And the stand that the DRI being a Commissioner of Customs, ADG DRI being a Commissioner of Customs appointed by notification 17/2002, and hence assignment of functions as per notification 40/12 will apply to the DRI, appears to be ill-founded, since the notification 40/2012 was issued under the non-existent powers of section 2 subsection 34, whereas no such powers is conferred under the said section. Although the court did not comment anything on the eligibility of the exemption, it held that since the goods along with the literature was submitted for first check to the Deputy Commissioner, the period of limitation cannot be made applicable to the current case, as there were no willful misstatement or suppression of facts. So, in this case, the court did not go into whether the benefit of exemption notification is available or not available, and whether the deputy commissioner was right or wrong in clearing the goods under the exemption notification. So, the main issue is whether the DRA can issue a show cause notice under customs, and that was answered in the negative, and hence they are not the right, proper officers to issue SCN under customs. So this was followed by an instruction 4/2021 issued by CBIC on 17th March 21, where the instruction has been given by CBIC that any show cause notice where DRA has been investigating should only be issued by the jurisdictional commissionerate of where the imports have taken place and not by the DRA. So this instruction has come recently on 17th March 2021. And also, this case is similar to a landmark ruling which was given in 2011, Syed Ali versus others in Supreme Court, where it was held that the Collectorate of Customs preventive jurisdiction does not have any jurisdiction to issue notice under Section 28, since only the officer who did the assessment can do the reassessment, and the jurisdictional collector who admitted and cleared the bill of entry would be the proper officer to do the reassessment. So this landmark ruling came in 2011, and that case was also referred in Canon India Private Limited to for the DRI powers. So I think this was an interesting case, and which probably has given the bifurcation who has to issue notice and who's a proper officer under section 28. So I hope this video would have been useful to you, and we'll be discussing more case laws in our future videos. So thank you. If you like the video, please like, share and subscribe. Meet you in the next video. Thank you, friends.